Welcome back, everyone. This afternoon's Lunchtime Roundtable is on shifting paradigms in international arbitration, arbitration tribunals, party-nominated arbitrators, and diversity. The roundtable participants are Mr. Zhulkarnain Abdul Rahim, partner at Dentons, Rodyk and Davidson, Ms. Fu Yuet Min, Director, Dispute Resolution at Drew and Napier, Mr. Ashish Kabra, Head for Singapore of the International Dispute Resolution and Investigations Practice at Nishith Desai Associates, Ms. Myung-Ahn Kim, Partner and Senior Foreign Attorney at Yoon and Yang, Mr. John Liu, Partner at AllBright Law Offices, and Ms. Gitta Satryani, Partner at Herbert Smith Freehills. This session will be moderated by Mr. Kabir Singh, Partner at Clifford. Mr. Singh, please.
Thank you, Michelle, for that kind introduction. And hello to everyone and welcome to the lunchtime session or almost post-lunchtime session. Now, I'm acutely aware that in a sense, this panel may have drawn the short straw, and thus the challenge for us over the next 1 hour is really going to ensure an interesting and engaging session so no one falls asleep into their meals or at their screens. And you have my assurance that an interesting session this shall be. Now, the topic of shifting paradigms in international arbitration, arbitral tribunals, party-nominated arbitrators, and diversity is a highly relevant one. The issue of diversity and party-nominated arbitrators has really come to the forefront over the last 10 years. Most of the large and reputable international arbitral institutions, including the SIAC, are acutely aware of this issue and have made it a specific and strategic priority. Now you see this whether it comes to the appointment of arbitrators or whether it talks about the composition of their respective courts of arbitration or their boards, where there's an acute and then very active awareness of the need to ensure diversity, not just at a gender level, but on the various other levels we'll talk about. There have also been a number of recent studies on the subject, including, some of you may be aware, the ICA Task Force report on gender diversity that was released in 2020. We had the Queen Mary 2021 International Arbitration Survey that also addressed the issue of diversity. SIAC's own annual report 2020 talked about the breakdown of the number of arbitrators appointed. So, for example, of the 143 arbitrators appointed by the SIAC, 46, or that's about 32%, were female. Again, of the 32 members of the SIAC's Court of Arbitration, 10, or about 32% are women. So that, again, sort of shows the importance of the issue, and it shows why arbitral institutions are actually, aware of it. We've also had a bit of a report on GAR recently on the issue within the ICSID framework and how we are seeing a lot more increase in gender diversity in the kinds of tribunals that are being comprised. So today we have a highly diverse panel who will be tackling many of these issues in a roundtable discussion. Now, we've opted not to go with the presentation style and instead do a Q&A where we will be posing questions to the respective panelists. So we're hoping to have an engaging and a free-flowing discussion. And we'll cover a number of the topics that you expect us to, including, for example, what do we mean by diversity? What are the different types of diversity? Is it just gender, or do we talk about ethnic diversity, legal backgrounds, LGBT, disability, and the like? Why is it important? Does diversity actually make a difference? Is there a real need for diversity, or is the topic just being overplayed? What has the international arbitration community done to push ahead with diversity, and what more can we do? Whose job is it? Is it something to be left to the institutions? Should the governments be legislating on it in their legislation? Should counsel have to play a role? And of course, last but not least, what about the clients, the ultimate end users? How can we convince them to do more? And last but not least, we'll be looking at what more we can and perhaps should be doing to ensure diversity and its place in international arbitration. So quite a lot to cover over the next sort of 1 hour or so. And of course, we'll be very happy to receive the questions from the audience via the Zoom platform. I'm told you'll be able to address any questions, and we will try and save those for the last 10 to 15 minutes of our slot. So perhaps without further ado, let me sort of dive into the first sort of subtopic that we sort of came up with, which is really what kind of diversity are we talking about, and what does you know, a truly diverse arbitration tribunal look like? So, for example, as I mentioned, do we look at gender, geographic origin, age, cultural, ethnic diversity, LGBTQ, disability, and perhaps I'll turn to Yuet to start it off. So Yuet, perhaps on your part, you know, what are the qualities that you look for and see in a truly sort of diverse tribunal?
Thank you, Kabir. I think, Kabir, as you mentioned, I mean, I think a diverse tribunal will bring to the case, to the table, basically a diversity of age, racial, national, geographical background, different experience, and I think the number of characteristics are countless. But I think the diverse tribunal, I mean, the quality, I think, is the sum of their experiences. And the different perspectives I think that they bring to the table as a whole creates that diversity. So I think, I mean, for me personally, there's no one definition of that diversity. I think when it is not diverse, you can tell that it's not diverse. But I think the definition of a diverse tribunal is much more broad-ranging than one can define. I mean, that I think it's the perspective and experience would be the most important qualities, I think.
Thank you. Zul, now sort of turning to you in terms of the types of diversity, again, in your experience, what types of diversity do you think are truly relevant in the context of arbitration?
Thanks, Kabir. I echo actually what Yuet has said. I think diversity is an attractive quality on arbitral tribunals because it connotes a certain sense of holistic assessment and determination, and also presumes that there will be a more rigorous examination of the process and hopefully leading to better outcomes. So for me, besides gender diversity, I think the latest survey has shown that we have made great progress in terms of gender diversity. However, other types of diversity are sorely lacking. That includes ethnic diversity, cultural diversity, and also maybe geographical diversity, especially when you are dealing with international cross-border disputes. From my own experience as well, it actually helps to have a more diverse panel so that every aspect or nuances of the case can be better determined. For me, I think the most important aspect, of course, would be intellectual diversity. We do not want all cut from the same cloth, although looking differently. We want intellectual rigor. Counsel want their submissions to be tested and evidence to be examined properly. And I think users, clients would definitely look at that and appreciate the rigors of the process brought upon by the diverse panel, and in terms of what they bring to the table, experiences, expertise, and also intellectual discourse.
Thank you, Zul. So Myung-Ahn, perhaps sort of turning to you now, how does one really address a concern that, you know, such systematic and concerted efforts to ensure diversity, and again, some of which we'll talk about more in the discussion, are really just viewed as symbolic tokenism? So in a sense, you know, having a woman arbitrator for the sake of it and not really merit-based. I mean, is that really a view today, or do you think that there's been, you know, a genuine attempt to sort of right the problem?
That's a really excellent question. I guess that type of argument is quite akin to what we've heard perhaps in regions like the United States, where the affirmative action was controversial for decades. And the issue about forced, systematic, or concerted efforts just for the sake of ensuring diversity across the board, and how that interacts with merit-based assessment. That type of discussion was at play for decades. But I guess in the context of where we are in international arbitration, As our colleagues have helpfully noted, we've already seen the realistic need to ensure diverse backgrounds to be reflected in the adjudication process. But in terms of what you just asked, how do we address the question of symbolic tokenism? I guess the answer lies in the ability to delineate the relevant nature of the dispute in each of the cases, and how that type of or nature of the dispute requires a certain type of diversity or background to be relevant for the tribunal members and ultimately the parties to be assisted in the ultimate way. What do I mean by that? I guess we can take a look at examples such as ISD, international, state investor-state disputes. One of our speakers has helpfully pointed to the 2021 Queen Mary University's empirical survey. And I also found that survey outcome to be quite helpful and relevant in the sense that they kind of refer to these types of disputes where a specific background or understanding or relationship with a certain culture or country per se may be quite helpful in determining the actual substantive dispute of the case. I mean, in the context of ISD, if a substantive legal proceeding or legislation of a particular country or a provision in the FTA between the two relevant countries become a hotly contested issue, one would actually expect the tribunal members to have at least some meaningful knowledge of that type of substantive dispute and law. And so in that regard, ensuring that type of attribute to come into the profile of the tribunal members would be quite helpful in ensuring meritocracy and also fending off any kind of unwarranted, argument that's just a symbolic tokenism.
Thank you. No, that was very helpful. So I want to sort of next explore, I suppose, the actual substantive part of all of this, which is the concern, right? So how does diversity actually improve the arbitral process in real terms? And I think this is something in particular the users will be keen to know about, right? Because it affects them. So whether it's in terms of the decision making, whether in terms of the merits, the quality, the reliability of the decision that's being reached. And again, some of these points have been addressed in the ICA report. So perhaps turning now to you, Zulbek. So what is it that the users of arbitration are really looking for? I mean, in the process, and is diversity really a big deal for them?
I think we need to look at the most popular or the most sought after institutional organizations or venues that have been used by the users themselves. I think Singapore is up there, New York, Paris as well. And actually, the bulk of the majority of the users are looking for certainty, and in terms of outcomes, in terms of predictability for the disputes. And also for during this pandemic situation, they're also looking at the most cost-effective way to resolve their disputes. Not necessarily diversity in terms of the tribunal or the development of the law in that regard, because after all, we are dealing with commercial men and women. However, I would offer to all users this particular proposal, right? That diversity would also bring about a more rigorous process, like I alluded to earlier, in terms of better decision making and also intellectual rigor on the panel in and of itself, where we talk about certain disputes, for instance, investor-state dispute. If all the tribunal is made up of a particular state from a particular cultural background, ethnic race, then it brings about a perception of lack of impartiality. That is not really helpful to the process. While perception is one thing, it also gives certain dissatisfaction or certain sentiments that parties do feel that they have not had the best out of the process. So I would offer that at the very least, diversity would help in certain disputes, provide the impartiality, provide also the opportunity for other aspects or nuances of the case to be brought forth.
Okay, no, thank you for that.
Can I add to that, Kabir?
Yeah, Gitta, please do.
I think Zul brought up a very good point about what users are looking for in terms of the integrity of the process. And you know, in arbitration, everyone always talks about looking for a neutral forum. And I mean, essentially, if you break that down, essentially what people want is a process that's fair and people who decide the dispute without bringing in their preconceived notions or their biases. And that's why diversity helps, because it ensures that the candidates you select as arbitrators are able to come in from that background, from that perspective of I'm neutral, I don't have preconceived notions about the parties, I don't have biases about the dispute, and I'm here to offer a fresh perspective, but a fair and hopefully a correct one in terms of determining the outcome.
Yeah, no, that's right. Myung-Ahn, can I turn to you now in terms of the kind of dispute where you know, a diverse background might be useful? Again, you mentioned both you and Zul mentioned the investor state context, but I mean, in the commercial arbitration context, for example, do we think certain kind of disputes, just take, for example, intellectual property or shareholder disputes, construction disputes, which is to name a couple of common options, right? Do you think any of these, for example, would benefit from a particular diversity? And if so, how would that actually contribute to the rigor and the reliability and sort of, you know, the quality of the ultimate decision making?
Sure. In terms of diversity, I guess it could be a philosophical question, but it's also a practical question in the sense that diversity can come about on the basis of a particular tribal member's knowledge in a specific field. So in the event that particular candidate does not have the requisite knowledge of the substantive dispute at hand, then that does actually hurt the party's chance of obtaining a neutral and very rightful outcome from a merit-based process. And I kind of go in a roundabout way in explaining this because putting aside this, you know, public international law arena of investor-state dispute, well, one can easily think about, you know, as you mentioned, a specific field or industry wherein a technical knowledge in that particular specialized field becomes a key factor. And if you actually think of that from that perspective, it's not necessarily limited to, the concept of diversity is not necessarily limited to one's ethnicity or just cultural background, but actually that person's specific knowledge and expertise and ability to grasp the diverse nuances of the substantive disputes that may be unique to that particular field or industry. And so one may easily indicate that diversity in terms of having an ability to obtain an arbitrator who may not necessarily be a legal practitioner, but who may actually have a technical knowledge to understand the realities of the particular industry and specialized field and be able to contribute with meaningful questions and answers and adjudication might actually enhance ultimately the diversity and the reliability of the process in itself.
Thank you. I'm going to go slightly sort of off script and go on to Ashish and John for your views on two sort of areas. Ashish, obviously you've practiced in India, you're in Singapore, and you know I know from the stats today that a number of our users and a number of our audience are from India, so I think they'll find the question relevant, hopefully. I mean, one of the experiences many of us have had in the Indian arbitration context is the preference, I would say, for many Indian parties to appoint a retired Indian judge. And quite often with a 3-member tribunal, you then go for 3 retired Indian judges. Now, given just the way the judiciary probably is, you know, you end up quite often with 3 retired Indian male judges. which is not a very diverse, tribunal by most standards. So, I mean, how does this sort of issue play up in the India context? I mean, is diversity important at all to Indian clients, or are they just looking? I think somebody else mentioned earlier. Look, we don't really care who decides. We just want a quick, efficient, cheap, resolution of the dispute. So, maybe some comments from you on that.
Thank you, Kabir. And I think let me start with the latest development in context of Indian judiciary. This month, we had a certain new set of judges elevated to the Supreme Court of India. And now we expect that in 2027, we will have a first female Chief Justice for India, which is a very big development in context of a country the size of India and how it's contributing to this. So it sort of reflects, and there are obviously other judges as well. 30% of the judges which were elevated to the Supreme Court were female judges this time around, which is again reflective that yes, in India, we have the problem of retired judges coming in and giving their, and they being appointed on tribunals. But slowly as the ecosystem is changing, this would also change. And there are one more point that you made, Kabir, was what do clients say? And people often say that it's the client's demands and our responsibility towards clients that we go for a known name. And that's why we have these set of people who we are going to and would often revert to appoint them as arbitrators. Now, even in Indian context and in international context, at least I don't think that holds much water, or this reasoning holds much water. In fact, if anything, it should be the opposite. It is your responsibility towards the client that mandates you to give or to suggest to the client a diverse list of arbitrators. We are now in an age where ESG is driving the decision-making for the companies, and diversity is a key pillar of social. I think most of our clients and other clients, international clients, they are, I think the amount of time we all spend filling up D&I forms from client, diversity and inclusion forms, which clients send us, I think that is itself reflective that the clients don't want, or this reasoning that we give that is responsibility towards client, that basically that reasoning no longer holds water. And most companies, I think the forms have also changed and their requirements have also changed. What most companies now ask you is not just about your workforce or your number of people who are female or coming from diverse backgrounds. They actually ask you number of hours billed by them on their particular matters. Companies like Shell, Coca-Cola, Novartis, and the list is just increasing. That we can add a multiple tech companies to this list. These are the requirements that they now have. So in light of this, I think that on the other point as well, that can you say that's responsibility towards client that allows you to go back to the repeat names? The answer is no. I don't think that holds any good any longer.
Thank you. No, very, very interesting perspective. Thanks, Ashish. John, can I turn to you sort of perhaps in the Chinese context, again, of another very large base of users of international arbitration. What's your experience been? I mean, how important is diversity to a Chinese client? And, if there is such a, and also, I suppose, from specifically the civil law angle, given the background there, do Chinese clients, insist on having, someone from a civil law angle in a common law dispute, for example? So, can you talk us through some of those issues in that context, perhaps?
Well, thank you, Kabir. So, in China, the clients doesn't pay a lot of attention to gender diversity, actually, in arbitrators, and the arbitration institutions also do not publish any numbers about the gender diversity. I think the issue is that, you can see gender diversity in the court, that there are definitely more female judges than male judges in many courts in China. So maybe female law students go to court. And there are a lot of mock arbitration in China. You can see definitely maybe 80% of the participants are female students. So let's say in maybe 10 or 20 years, there will be definitely more female legal practitioners in China than male students or lawyers. But there is a much concern on the legal background diversity. We pay a lot of attention whether the arbitrator is a lawyer or a retired judge or a professor or an in-house. So I should say that people of different legal backgrounds, they have different understanding of the same legal issue. Someone are like can be quite aggressive in rendering award, in like agreeing on the damages, on number of the damages. Some well, maybe professors or retired judges are more conservative. So currently, the majority, I should say, around 30 or 40% of the arbitrators in China are lawyers, and after that are retired judges. So when choosing a arbitrator, the client prefer to choose someone, well, through their lawyers, someone they trust, and who can be like preferential to their result if they think this case will need some aggressive arbitrator or someone not that aggressive. Yeah.
I see. Interesting. Thank you for that perspective. Gitta, can I just turn to you for another large jurisdiction? I'm sorry, I know I'm going down the big ones, but Indonesia, I mean, that's again, something close to your heart and your practice areas. I mean, how is the concept developing there? What is the view of Indonesian related parties to the issue of diversity? Does it matter at all? Does it not?
Well, you asked a very good and interesting question, Kabir, and very much depends actually on where the arbitration is seated. Because if, let's say, you have a Jakarta or Indonesia seated arbitration and using a domestic set of rules or ad hoc set of rules, I think there's less of that consciousness. And also, to some extent, it's driven by the close nature of, say, the list of arbitrators in Bani, and you will see that a majority there will be men. So in that respect, users in Indonesia who are more used to domestic institution and domestic arbitrations will be less conscious about issues of diversity. But that's certainly not the case for the users who are well-versed or well-experienced in international arbitration, and particularly SIAC, because that's a go-to institution for many of the Indonesian businesses. And for them, they do see it as an issue and a relevant factor when trying to choose an arbitrator and nominate an arbitrator. And also when considering, when candidates are presented to them by the SIAC. Interestingly, what they're less concerned about is not so much gender, but more of what I loosely call cultural background. And what I mean by that is, whether they're more concerned about whether the person is going to understand an Indonesian entity or an Indonesian business or practices, and whether the arbitrator will be sensitive to the difficulties or the challenges around doing business in Indonesia, for example. So to that extent, they are actually more alive to diversity, but the focus is less on what we traditionally think about when we talk about diversity, which is things like gender, sexual orientation, but more about that cultural experience and educational experience that may be relevant in how they view a dispute or a party.
Absolutely right. No, I think that's a very good point, because we sort of pigeonhole diversity to sort of gender when there's a lot more to it. And again, as you say, the sort of cultural background and the understanding can be equally important and often very, very important to commercial parties. You had been turning to you, I suppose, so trying to round off this topic, in your view, and again, we've heard from others as well, do diverse tribunals really arrive at better decisions, and are clients really missing out, if they discriminate against diversity and, sort of go for the tried and tested, what's your view?
I think it's difficult to say that, just because you have a diverse tribunal, they arrive at better decisions. But I think we are at the stage where we can at least say that, having a diverse tribunal is equally capable of arriving at a fair, at a nuanced decision. And in fact, I think the plus point is that you do hopefully avoid, diverse tribunals. You avoid the situation of an echo chamber. People, people of the same background talking about the same things and arriving at the same conclusion. Of course, you could have a diverse tribunal arriving at the exact same the conclusion, but I think there is a perception, at least, that different considerations have been taken into account, and the submissions have been given, it's time of the day, and you arrive at what we would consider a more holistic and well-reasoned approach to a certain issue. I think that is quite likely or more likely in a situation where you have a diverse tribunal. On the issue of whether clients are missing out, I think all of us, who are in the business of appointing, nominating arbitrators, we do realize that sometimes, you find that the pool is quite limited. I mean, you do have the well-known names, but I think there's no reason why clients should shortchange themselves by limiting themselves, to a smaller group when there is a much more diverse and a bigger group of, potential arbitrators. If you're talking about diversity among arbitrators, at least, is concerned that you have a much bigger group that you could choose from. So why, shortchange yourself and limit yourself to a much smaller group? I find that limitation quite irrational. I think all of us also face the same problem, when you try and nominate or suggest somebody who is not so well known, you're often faced with the question of like, why, but there are all these, people with so much experience, why are you choosing somebody else? And, those kind of considerations come into play. Maybe somebody from a diverse background is able to understand a particular cultural aspect of the case better. And while that cultural aspect, even if it's understood, may not lead the decision somewhere, but at least it is considered, the argument is understood. I think that is the key difference and the key hope that we have, in having diverse tribunals.
Okay, thank you. Zul, sort of just turning to you on the last point. Again, you see the common theme from what I've heard in the panel as well is that diversity is important, but ultimately, and at the end of the day, unless we all sort of convince the clients about it at some level, it's going to be a hard sell, right? I mean, the institutions can do their part, but ultimately the clients have to see that as bringing some kind of benefit. So as you just said, for example, whether it's a commercial understanding or some kind of reasoning issue. So from your perspective, I mean, how can we sort of increase this understanding that diversity is, important? And what are some of the things that we can be doing better on this?
Well, thank you, Kabir. I think the paradigm shift begins with all of us, the counsel involved, looking at the specific needs and requirements of the case. What would be the best choice as an arbitrator for that particular case? I'll give you an example. It doesn't mean that just because clients are from a specific background or a corporate culture that we want an arbitrator that actually is from the same culture as well. Actually, the converse is true. To actually appoint someone that actually understands the other side well, so that any particular submissions made by the other side can properly be understood and verified or tested by an arbitrator with that relevant experience. I've been involved with cases where cross-cultural and cross-jurisdictional parties, right, with different culture of working innately ingrained in the society. And it actually helps to have someone who understands from the other side to actually sieve out frivolous arguments, frivolous submissions, and test them. So I think for me, clients would have to appreciate this, and it is incumbent upon us, counsel and in-house counsel, to actually see the value of selecting such arbitrators, albeit maybe the pool is very small when you sieve it through, right? But from the response in the survey as well, I think just short of 50% of the respondents actually believe that this is an important role that counsel play, because the trust that John mentioned earlier is really true. But there's also a trust between the counsel and client, and the counsel in terms of who is the best man or woman fit for the job.
Yeah, no, that's right. I want to now explore, I suppose, one of the other themes, related themes, which is really how does diversity enhance the legitimacy or the confidence in the outcome of an arbitration process? And, is there any real connection between diversity on a tribunal and the parties' perceptions of the arbitrators, independence and impartiality? Again, this was a point raised in the Queen Mary survey. So is that really, is that really right in practice, or is that just, an observation? So, Gedwin, I suppose turning to you, will arbitration really, the awards be seen as be more fairer and more legitimate if tribunals are diverse, or do you think it matters not?
I think it helps in perception, and we all know that, you know, whether you do court work, whether you do arbitration, justice has to be seen to be done. So I think it does help in the perception, at least. It is beyond just being a buzzword today. It is. I mean, and I think we start from the point that discrimination is wrong to begin with. I mean, it is wrong to begin with, and therefore, you know, then you move towards the discussion of diversity. And I think the perception works. And if you look at the Queen Mary survey, more than half the respondents stated that diversity across an arbitral tribunal has quite a positive effect on their perception of arbitrators' independence and impartiality. So I think that is a good reflection. Of course, we still have to deal with there are still more than 37% took a neutral view, whereas others basically considered the inquiry entirely redundant. So I mean, we are some way from, you know, saying that it is that everybody perceives that to be an important factor. But I do think that, especially in very controversial cases, in very controversial awards, having that diversity would help, because as we all know, you know, sometimes when you end up in a case and you appeal, the decision is not wrong, but you feel that you've not been heard. And therefore, there is that perception that, you know, that justice has not been done. And I think having that diversity would help that process and that perception.
No, good point. And again, I suppose a related point on what you just said, which is that in cases with a particular sort of angle, so for example, in an arbitral award that might have more of a public interest, and again, the investor state, you know, one is a good example, right? I suppose that issue would be more likely to attract diversity as impacting the legitimacy of the award, because people would want, you know, the broadest range of views and the broadest perceptions before. And again, as you say, you know, especially in the controversial cases. Myung-Ahn, can I turn to you in terms of some of the factors that impact a party's perception of an arbitrator's independence and impartiality? I mean, obviously not being connected, that's a basic point, but beyond that, you know, what do the parties look for? You know, do they want someone in a wholly different field just to show that, you know, this person has got no connection whatsoever, or is that not right in practice?
That's another good question. I mean, just by way of analogy, I can just share one recent, you know, personal experience. When, as counsel, we were recommending some of the candidates for an arbitration involving, you know, cross-border disputes. One of the co-counsel member, he is from, you know, what you might consider as a traditional majority, you know, group type of background. And he basically said, well, are we going to go there, the flowery, fuzzy area of diversity? And, you know, why are we even talking about it? But in that context, that mattered, because we were, you know, thinking about the, you know, the delineation of civil law versus common law backgrounds, and how that difference in the background could come into play when they review, you know, promissory estoppel principle and the document, you know, production process, the level of aggressiveness that might be expected from the counterparty, and how that might be, you know, broached by the tribunal members in turn. And so, long story short, what we might want to just come back and say is that it all boils down to the nature of the dispute and the relevant experience that could actually contribute to the substantive and accurate adjudication process, as opposed to an artificial approach to ensuring a particular gender or particular ethnicity to be involved or reflected in the ultimate selection process.
Okay, so perhaps just ending off with you as well. I mean, have you seen, you know, the diversity element actually impact, you know, in a positive way, or maybe not, the actual dispute resolution process? So something where, because of the diversity of the tribunal, you know, you actually came to a result which was perhaps more favorable, a better, you know, reasoned decision, more credible decision than not. What would...
Absolutely, you know, more favorable and credible in turn. We were dealing with a construction dispute in Kuwait, and the substantive law of the contract was Kuwait law, in which I don't really have a lot of expertise. And so we actually had to ensure that one of the tribunal members or ultimately the presiding arbitrator was actually indeed of that particular background or was having some meaningful connection or relationship or understanding of that legal background. And ultimately the member who came on board was a female arbitrator based in Kuwait who had substantive construction experience in that jurisdiction and had international arbitration background as well. And so we didn't really approach it from the perspective of, oh, we need to have a female arbitrator with certain, minority ethnicity background. But when you actually delve into the substantive issue and think about how a particular industry or specialized knowledge in that dispute becomes relevant, then it naturally, flows into having to have an arbitrator who has that relevant experience and understanding, which in this time and age is very much interconnected and goes beyond national border.
Thank you.
Can I add to that?
Please do, John. Yeah. It's good to
Thank you. I think in terms of diversity in international arbitration cases, the issue of civil law background versus common law background is quite important in this scenario. A lot of Chinese companies are arbitrating in Hong Kong, in Singapore, and elsewhere. And well, the dispute may apply on Chinese laws or like common laws, right? And normally the Chinese clients will prefer to use Chinese lawyers co-counsel with foreign lawyers in foreign proceedings. And normally, and the other party, the foreign party, in most cases, common law legal system lawyers and clients. And in this situation, we are quite concerned if the presiding arbitrator has only common law background. So it means that the tribunal tend to have a mindset under the influence of common law legal system. And so in these kind of cases, I prefer, or I will raise an application to the institution to appoint someone who has at least some knowledge or even living experience in China or in civil law system, so that he can understand the requests raised by a civil law client. Yeah, that's quite important.
Yeah. Okay. That makes sense. And again, I think it's consistent with a lot of the experience that we've had as well. I want to go on now to sort of the sort of making it work. And again, I explored this in one of my introductory themes, which is, I think the general view on the panel across is that diversity is important. There are real and tangible benefits, and we've seen, examples where that has worked. But I suppose getting there is an issue, right? And I say, from that perspective, one of the themes we want to talk about is who has that responsibility for ensuring diversity actually makes it through, right? And for improving diversity, I mentioned earlier, there are various stakeholders, the institutions, the governments, council. Gitta, you mentioned that earlier as being one of the responsible, and of course, ultimately, the end users being the clients, right, who are using the arbitral process. So Ashish, perhaps turning to you on this one first. Who do you think should shoulder that burden? Is it a joint burden? Is it an individual burden? Or is there a magic bullet that we're all not aware of?
So while the topic for today's discussion at least was focused on arbitral appointments, but when you ask about whose responsibility is it, I think we should look at the whole ecosystem of arbitration, because when we look at the whole ecosystem and attribute responsibility, that is where the eventual end goal of arbitral appointments also changing and the diversity coming into that would come in. And when we look at the ecosystem, we'll automatically get our answers. Let's start first with the appointment of arbitrators itself. Obviously, it's the institutions who are the final appointing authority. So obviously, as a first point, we go to them. But equally, then we go to councils who are giving those names as suggested earlier. And along with the councils, the clients who sort of will rely on the councils to come up with it, but at the end do have a say, because if they make a statement, that it's rarely that the councils will go against it. We also have co-arbitrators who appoint the presiding arbitrator, so they can have a say when it comes to appointing arbitrators. But as I said, it's not just about arbitral appointments. It goes to other areas as well. For example, tribunal secretaries. Arbitrators should take care that when appointing tribunal secretaries, they also take this into account. When it goes to counsel teams, then it's the leadership of the law firms, and again, the clients which come and play a role. When it comes to arbitral associations, it's the senior stakeholders of our arbitration community which need to stand up and bring about this change within the arbitration associations and groups. So when we say we want to attribute responsibility, I think we should start looking at the whole ecosystem and then attribute, and obviously then we'll easily come to answers at individual levels. And this also shows that the responsibility doesn't lie at one place, it's obviously spread.
Yep,
Can I add to that, Kabir?
Yes, do, please.
Yeah, I think Ashish raises a good point about, how it's a whole ecosystem, and I completely agree with him. But one other thing that sometimes gets overlooked, I feel, when we talk about arbitration, arbitrator appointment and diversity, is that it doesn't start, your story as an arbitrator doesn't start right there and then. It's actually a culmination of your experience as a lawyer, or I don't know, as an engineer, or as a professional before you get appointed as arbitrators. Most arbitrators come through the private practice system. And actually, I do think that law firms have the responsibility because they do the hiring process, right? So it almost starts from who you hire, who you nurture, and who you promote, because those are the very people that will go through the system and will gain that reputation as a good and credible arbitrator. And get recommended to clients who then feel comfortable saying, yes, that person, is the right person to hear this dispute. So in that sense, you have the entire ecosystem, but it also needs to start a lot earlier.
Absolutely. I think that's right. It's about making that pool available and sort of growing that pool of diverse arbitrators, because without that, you can't start, right? I mean, there's nothing to pick from. Myung-Ahn, can I turn to you on something which is on the topic again of encouraging diversity? Gitta raised a good point about making it a diverse pool, actually doing something from the ground up to ensure you have a pool of diverse arbitrators. But is that enough? And does more need to be done? I mean, either at the institutional level or even at the government level, for example. Do any of us think that it is reached a stage where, for example, our International Arbitration Act should be amended to include an aspect on diversity, or that the institutions putting out model arbitration clauses should say, for example, in a panel of 3 arbitrators, one of whom should be a woman? I don't know. I mean, these are radical suggestions. I'm just asking, do we think we've reached there, or do we think that we're still going to take a sort of a soft nudging approach to the issue? Myung-Ahn, this was supposed to be your question, but I mean, I'm happy to hear views on the panel because I think it's quite a live one. Who wants to start? Yeah.
I'll just briefly answer and then I can yield to the rest of the panelists here. I couldn't agree with Gitta more. I mean, I think it's a really critical point. And on top of that, Kabir, what you mentioned just now rings bell. I mean, if you're really going down the route of being radical as just having a quota system, requiring or at least imposing some kind of guideline that at least 1 out of the 3 members of the tribunal must be of a certain background. I mean, I can see how that is in line with the fundamental, general principle of wanting to reflect the diverse backgrounds and realities of the, today's world, but at the same time, it can backfire. I mean, ultimately, it comes to, we're all lawyers. We're all driven by logic and practicability of, our resolutions and recommendations. And if we just go down that artificial mechanical, route, that it could actually trigger some legitimate concerns of sacrificing merit-based process and being sort of counter-majoritarian, creating that kind of dilemma along the process. So in turn, we as individual counsel should sometimes hold hands and sometimes try to edify our own clients, based on logic and practicability of ensuring a certain background and diverse attributes of the tribunal in that particular case on a case-by-case basis. Now, if we're dealing with a heavily Eurocentric dispute involving, 2 European countries dealing with ISD dispute, then it may not necessarily require a certain, diversity in the ethnic background either. And so this is my just windy way of saying that it's on a case-by-case basis. And ultimately, for me, the running theme, underlying fundamental running theme is what is the diversity about in the context and in the nature, in relation to the nature of the dispute that you're dealing with on any given day. And then against that background, you need to kind of figure out what type of backgrounds or specialties or expertise, or even ethnic background, cultural backgrounds might be at play.
Yeah, no. You do you have a different view? I mean, just taking that example, right? So my counter to that would be just taking a very basic gender diversity. One could argue that at every level, it would probably benefit from not having 3 men on a tribunal and having 1 woman. So in a sense, you can cut across the construction, IP, shareholder disputes and say, look, in any commercial arbitration, why not, at least try and encourage arbitral tribunals to look for one of the members to be a female arbitrator. So would that kind of work? And do you think the community is ready for something like that?
I'm always torn when it comes to this issue because I have something against affirmative action. I come from Malaysia. Of course, affirmative action there is a different story altogether. But I think for all of us, here, I don't want to generalize, but for the women here, I think many of us have benefited from this whole movement towards gender diversity and things like that. But at a certain level, we also hope to just compete normally, not just compete equally. We don't. None of us hope that we are chosen only because we are different. We all, as I think Zul mentioned just now, we just want to choose the best, the most suitable, what we think will serve the clients the best, in the best way possible. But I think at some level, I'm not sure whether the question is whether we are ready for it. In fact, I think the question is, are we ready to move out of the artificial mold of to say that we must have, let's do it just so that we can have somebody different. As I said, I've benefited from that myself. I'm not going to say it is wrong or it is bad, but I think at a certain point, I hope that we are ready to move beyond that, and that we will reach a point where we have a diverse group of people who are already in and who will bring other diverse people in, such that this group is forever evolving, and we get this large pool of people that we can choose, always be able to choose the best person from. So I don't have a real answer to this. I feel torn about this issue all the time, about whether sometimes I think many of us question, am I just there because I'm young? Am I just there because I'm female? I think it's a difficult question for many.
No, thank you. Very, very, very pertinent comments and
Hi,
concerns. Zul, please, yes.
Something? Yeah.
I suspect this is one where we'll have quite a lot to say from everyone. So please
Yes.
do.
I totally agree with everyone's inputs. I think what Ashish mentioned about the ecosystem and what Gitta talked about in terms of the leadership of the law firms as well, that's important. I proffer 4 facets to it, right? First, of course, on the leadership in the law firms. I recall for one particular matter, an associate told me that choose me because I'm the best and not because I'm a woman, right? So I think that must be the mindset, and that's ingrained within us in the Singapore context of meritocracy and the best person for the job. And it's indeed quite heartening that all our law firms have actually nominated us for this panel, right? Entrusting their trust to us. So there must be supply to build up that experience for counsel, for people from diverse background to able to relate to clients, relate to the industry. That's one. The second thing is obviously the institutions themselves, right? But here we need to balance it with parties' autonomy in terms of how parties have a right to select the arbitrator that they want. However, they do not know what they do not know, right? And there are good arbitrators out there that may not particularly fit the perception or the mold that they have in mind, but ultimately would be good for the job. So I would suggest probably that although the responsibility cannot be on the institution alone, the institution can actually assist in terms of a hybrid model where they can have a list of available, able, capable arbitrators from diverse backgrounds that parties can select from. And this list may be curated upon maybe a confidential query basis based on nationalities from the outset. So then there will be a list that is sieved out based on diversity, geographical, cultural, or even availability of arbitrators. The third thing I would want to say is actually our law schools, right? I was in my shipping module classes, and I think they're predominantly dominated by male. And it sets the tone for practice later on. And this is something that the Singapore government has been talking about in terms of increasing participation of our daughters, women in the STEM industry, in certain aspect of practices of law. So it is a work in progress, and I think we need to also have a more diverse approach in terms of our law school modules participation. The last thing I think you mentioned about government, I think the last thing that we want to have is government intervention. Speaking from a member of parliament's perspective, we have debated it in parliament how anti-discrimination legislation can be better built, and you know, you've heard on the National Day rally about racial laws, TAFEP guidance now being enshrined as an anti-discrimination facet. So I think with those background in mind, we do not need a clear, quote-unquote, affirmative action for the industry, because everything else takes guidance from the fact that we should aspire to be a society where meritocracy counts, discrimination fails.
Thank you. No, very, very well said, and I thank you for that perspective.
Just to add on,
Gitta,
sorry,
yeah, Ashish, I'm coming to you as well. So maybe we'll let
you.
you.
I just wanted to add because the women on the panel have been very kind and not propagated a fixed requirement, and I wanted to be the devil's advocate here and say that probably not at the tribunal level, but at all other phases, we can definitely have a fixed requirement. Again, echoing Zul's point that not by legislation, but through our community, by tribunals stance, by the institution stance, by the council's leader, the law firm leadership stance. And the reason is because everybody focused on merit. And yes, the focus has to be on merit. But in the society that we live in, obviously, some are in the developed societies, some are coming from less developed societies. The cultural nuances are different. The opportunities of showing your merit are also different. The responsibilities are different. And therefore, not always simply leaving it on merit is adequate. So I would probably just put over here that probably not at the tribunal level, because who knows which party will appoint or which party's right goes away. There are many questions which arise. But at least at the other levels, we can definitely propagate for some requirements. And that is in fact happening.
Yeah, sure. I mean, actually just taking that point, you know, you talk about that level, and let's talk about it at the sort of council level, right? So again, all of us experience arbitration council, you know, we often nominate, and I think Yuet mentioned this, right? One of the small pool, no names, because that's often the sort of safe choice, right? For the client. And, you know, the excuse obviously from all of us is going to be, look, you know, I'm not going to stick my neck out for someone I don't know, right? So why not just go for someone tried and tested? You know, if something goes wrong, at least we know it's you know, it's a big, I mean, that's the thinking, right? Unfortunately, that is a reality, and that often plagues it. But let's take an example where you had, you know, on merit, you know, two equally competent and able candidates, one of whom was a woman and one wasn't. Would you actively then, you know, recommend to the client and say, look, you know, I think, you know, let's go with the female candidate, or do you think council are not ready to do that? Again, I want to hear from the men and women on the tribunal and on this panel. I beg your pardon. You know, because I suspect your views might be different. So starting with you, Ashish, since you raised this issue.
It's important issue as well. And as I said earlier, I would actually put it this way, that it is our responsibility to actually say to go with the female choice at that point in time, or rather, let's not put female choice, it could be ethnically different, or because all the other criteria of diversity, it is actually a responsibility to do so. And I also say, once you actually say that to the client, and if you're dealing, and most of the clients, if given their internal policies, how they are shaping up, if there are clients which have actually received a PE funding investment from sort of institutional investors, their internal policies are likely to dictate them to go with the other choice. So therefore, we should never shy away from actually propagating and giving that option to the client and suggesting why and the reasons for. Yes, final decision may be theirs, and we have to go by that as counsel.
Yeah. No, exactly.
I do agree with Ashish in that.
Go ahead.
All else being equal, it is our responsibility to do that. And particularly when it comes to diversity, people often assume it means you have to always pick the diverse candidate to the exclusion of others, but that's not right, right? Promoting diversity is about being conscious of the fact that you may have unconscious biases that prevents you from choosing someone who is diverse but is equally qualified. I think that's what diversity is about. So you're not picking that person because she's a woman, he's a certain ethnicity. You're picking that person because he's qualified, and he wouldn't typically be considered in any other situation because of a lack of opportunity.
Great. Okay, I've been given a time warning by the organizers. We've talked a lot about this. This is probably a 3-hour panel, but we have to do it in 1 hour. So I need to move on to the next topic, and that's on party nominated arbitrators. Again, there's a diversity element here, but also a broader discussion. Is this concept really part of the problem, right? So is the fact that parties are given, in a sense, the absolute ability to nominate the arbitrator candidates part of this issue? And what if parties gave up the right to nominate arbitrators and left it to the institutions? And again, we all know there's been some academic, publications on this, some radical suggestion on the, abolishing the concept of party appointed arbitrators altogether, right? I suspect the view is going to be that we're not ready for that approach, but I'd like to hear from the panel. So perhaps, Gitta, starting with you, how important is the right to nominating an arbitrator? And do you think this is part of the problem when we talk about diversity?
I'm probably going to be obvious here because I am from the camp that believes that, being able to appoint an arbitrator is one of the core tenets of international arbitration. And it is for good reason, right? Sometimes, as Myung-Ahn has said, you do have very complex or very specialist dispute that it would benefit from, sometimes not even having a lawyer. Say you have an engineer as a party appointed arbitrator because it requires that sort of skill set to help determine the dispute more effectively. So I do think that it's not a right that you can easily remove without then changing the nature of international arbitration. Is it part of the problem? Yes, but not because you allow parties to choose their arbitrator. I think it's part of the problem because in the past, it's easy for parties to fall back on the familiar. So what you need to get parties to do, and that's the collective, again, to use Ashish's words, the collective responsibility of counsel and clients to broaden your horizon and not just fall back on that small close list of people that you assume will be the best placed people, and think about, are there equally qualified people who could also be appointed as an arbitrator? It's the same technique that institutions have deployed in recent times, and the same technique can be deployed by counsel, by clients.
That's a fair point. John, can I turn to you in relation to the Chinese party perspective? Again, you mentioned earlier, obviously it's a very sort of closely held right to appoint an arbitrator. And again, that's perfectly understood. But what do you think of this topic? I mean, do you think at some level, perhaps putting some controls over the absolute right to appoint anyone and sort of nudging parties towards trying to make a decision in favor of diversity? Do you think Chinese parties, for example, are ready for something like that? Even if we use a soft touch? No? Very quick answer, but yeah, please do explain.
Because Chinese parties love to have this right to appoint an arbitrator, and the Chinese lawyer will recommend someone they are familiar with, someone they trust. And even if I'm faced with two candidates who is one male, one female with same quality, ability, I will tell my clients that I prefer, for example, to use that female arbitrator, not because of she is female, just because she is more patient in this case, or she will warm-hearted, she will kind of make some I'm sorry to say that emotional decisions in this situation, which, for example, maybe our marriage in this case is not in our favor. So I will tell the client that there is some qualities in the female arbitrator that the male arbitrator doesn't have. So I think also it's fair to all the female arbitrators that you are chosen not because of your gender, but because of your special qualities, right? So that's the way I will approach our Chinese clients.
Okay, and maybe just building on that answer, I mean, you mentioned this, and I think it is a common experience for many of us that very often we try and go with the tried and tested, and parties will ultimately fall back to their counsel for recommendations. And again, Chinese parties in particular will hold the views of their counsel very dear, right? Because they're the relationship of trust, and they believe you will choose the best candidate for them. Now, that being said, I mean, is perhaps the lack of quality and transparent information regarding, arbitrators' capability, credentials, etc., part of the problem? So, for example, is could there be more done to ensure that the larger and more diverse pool of arbitrators become more visible, ultimately to the institutions and obviously to the law firms? Because between the institutions and the law firms, these two probably play one of the most pivotal roles in terms of influencing the selection process of an arbitrator or the nomination process of an arbitrator. So what is your view on the information that's available out there, obviously beyond just the internet CVs that we all get, but there are these professional organizations now that are selling data on arbitrators. I'm sure many of us have been asked to contribute on arbitrator CVs, what our experience is, very sensitively how arbitrators have done well as arbitrators, how they've not done well, and that information is now being sort of sold out to parties, right? Is that something that you think would influence the ultimate decision and perhaps can be part of the solution?
Yes, because there are a lot of arbitration institutions in China, and I believe one of them published the information of how many cases the arbitrator has handled in the past. Is it just 2 cases or 200 cases? So you can know the experience the arbitrator has, and but eventually the lawyer will choose someone they are familiar with. So I think it's the responsibility of the arbitrator to socialize with the lawyers, especially lawyers and the institutions. And also the institutions have the responsibility to promote those new lawyers, giving them new arbitrators, to giving them more opportunities like today to speak with others, to present, give them a chance to present their knowledge.
Okay. I'm going to try and move on to one or two of the next questions because we've run out of time. So I want to try and cover one or two of the topics. Again, one of the issues we talked about are some of the sort of barriers to entry for the underrepresented groups. Let's just call it that as a broad term. Gitta, in your sort of view, who are these sort of underrepresented groups? And really, what are some of the most important barriers to entry, from preventing them from getting into that pool, as we all talked about?
Yeah, that's always a tough one, right, Kabir, because there's a diverse list of who are the underrepresented groups, and different jurisdiction or region will have different groups being put in that category. The common one, obviously, you have gender, you have ethnicity, and then we talk about a little bit earlier on things like educational background, common law versus civil law tradition. So these are your typical, I think, your underrepresented group will be women, or we talk about, ethnicity. There's a lot of talk maybe in the last 2 years about, having more Asian arbitrators or Southeast Asian arbitrators. So then you also talk about legal traditions, people saying, there are more civil law jurisdictions out there, but the arbitration seem to be dominated by lawyers from common law tradition. And then people say also that, technically it shouldn't just be lawyers, there should also be non-lawyers, but they're underrepresented and they're often not considered. So that's the list, and it just depends on where you are and which stage of, I guess, development that region or jurisdiction is in.
Fair point. Fair point. It's a slightly unfair question towards the end because you can say a lot about it, I suspect. And we're running out of time. But anyway, Ashish, let's go on to this in terms of how we can try and encourage the solution. So in terms of education and promotion of arbitration in some of what we'd call the less developed jurisdictions on arbitration networks, what are some of the interest groups that are out there, whether you talk about initiatives like Arbitral Women, Alliance for Equality and Dispute Resolution, etc. Some of these that are already doing a lot. What do you think can be done, and how quickly, I suppose?
Sure, Kabir. So firstly, Kabir, I think I had the privilege of being taught by a great professor in arbitration, Dr. Patricia Shaughnessy. And I think that has helped me and brought me into the field, the position where I am, where I can speak at this Congress today. But I do recognize the problem that education is only available in key centers, for example, Geneva or Singapore or Stockholm or Miami or London or New York and so forth. So, and how do we spread that? That's a question that I was thinking a lot about right now. What could be a potential answer? And I realized that all of these institutions are attached, or all of these centers are attached with certain great names in the arbitration. And therefore, to move them and to say that they come to a newer jurisdiction, it's difficult. But what I did notice is that today we are in an age where regional arbitration centers are cropping up and gaining importance within each area. We have similar centers coming up across Southeast Asia, Africa, Latin America. I think this can practically be a good point or a good center or place from where we can expand in networks in all of these regions, provide the level of education that is required. If anybody needs to, that we all have to do our bits. We need to promote scholarships and all other things. But practically, I see that reaching out to these regional centers and then using them as the basis to go out in these regions, it provides a good networking opportunity to the existing field of professionals that we are in the community, and at the same time gives that education, promotes those networks in those regions. So I think that can be a good area. And the only other point which I said earlier, which I'll repeat again, is that one more thing that we all do is try and see tribunal secretaries that we all sitting on tribunals try and appoint. We try and get more diverse group. We try and find people from other spaces to bring in. So I think those are a few nuggets. And sorry, I've missed one point which you said earlier, the organizations. What can we do? As you named a few, Arbitral Women, they're doing great work. They have a very, very substantive list of women arbitrators who can be there. So in fact, anybody who says they don't have a choice or they can't find a particular women arbitrator, if they go to that particular website and check out their list, they will be put to shame by that very fact that they were asking those questions. So there are a lot of other groups such as ERA, the Equality Representation in Arbitration Pledge, which people can take, and they're doing tremendous job. But I think, yes, we can be part of these groups, try and contribute this way. But at the end, it says, like, it's this conscious being part of this group only makes you more conscious about your decisions. I think that is the key aspect over here.
Thanks, Ashish. Two more sort of points that I just want to sort of try and do in closing. Unfortunately, we've run out of time, but as I said, it's a very, very complicated topic. Yuet, just in terms of one of the groups that perhaps have not been thus far that represented, which is those with disabilities. And again, we know that the issue of disability in arbitration, the ICC, for example, has been a thought leader in this. They formed a task force on disability inclusion in international arbitration recently as well. How significant is this group when it comes to the issue of diversity? And where are we? Where are we in sort of trying to sort of include them?
Actually, when I saw the figures myself, I was a bit surprised. I don't have much visibility on this, but according to this disability charity scope, almost 20% of working age adults are disabled, and this number rises to 45% among those of the pension age 66 years old and above. That's quite a significant percentage, I would say. I think what we all miss out, and myself included, is that this range of disability, we are used to thinking of disability as something that is visible, but there's a lot of invisible disability among people around us, and ourselves included at some point in time. And I think that is the inclusion that we need to seek. And I think what I think will be important is to destigmatize this idea. But how do we do it? I think we have to normalize it. That's what we need to do. I'm not no professional in this. I'm not expert in this, but I would imagine that the entire process whereby people are used to dealing with this issue, where this issue is discussed openly, where people ask if anything is required, for hearing, in terms of accommodating, whether it's counsel, whether it's witness, whether it is, your user. We have to have, I think, an open conversation about these issues and make it not difficult. Because I think some of us even, look just from the perspective of, having gone through maternity. I mean, not too long ago, asking for that was a difficult thing. You had to ask for it. It's something that is not common. So I think putting it within the system, normalizing it, making it part of the process would help in some way towards recognizing, that it exists among us, especially the disability in the invisible form. I mean, that's my very.
Thank you. No, I think that's very well said on a very good topic. Last question for the panel, and Myung-Ahn, I'll sort of turn to you on this one, which is something we've all are going through now, and the whole impact of COVID-19. I mean, has there been any realistic impact of COVID-19 on the diversity issue? Has it made it worse? Has it made it easier through virtual hearings? All of the technology that all of us are used to now employing, has that made international arbitration perhaps more accessible to individuals who are otherwise, perhaps not considered? Or what's your view on it from the COVID-19 perspective?
Yes and no. My answer would be yes and no. I think we do all appreciate that, virtual hearings have been held, and in some aspects, it helped us enhance our efficiency, particularly in the context of, dealing with CMCs and procedural hearings. I think virtual mechanisms have been quite helpful. And it also, helped different diverse, traditionally non-represented or less represented groups to partake in webinars or a virtual congress such as this. But the level or the breadth or depth of their participation could be quite limited still, because even in the context of virtual hearings or virtual networking sessions, people tend to just group themselves with familiar, pre-existing groups and acquaintances. And it's a bit of a challenge for newcomers or traditionally non-represented groups to make meaningful headway into the discussions or networking sessions. And so at the end of the day, I was just wondering while listening to all of your helpful comments that at the end of the day, it's all about our matter of conscience, right? And conscientious decisions need to be made in order to enhance these matters of conscience. And we all need to make joint efforts and on a day-by-day basis. And I pledge myself that I'll be doing the same along the way, but it's been really, really helpful to hear all of you.
Thank you. Indeed, it's been a very, very enlightening session for me. I mean, both the sort of preparation and the actual session itself. And thank you all for sharing your views. Any parting comments from anyone as we've reached the end? I think we're slightly over time, so we might get cut off anytime soon. But anyone else want to say a final word? Ashish, please go ahead.
Yes. I think I'll just echo one thing that my colleague said earlier. It's just a statement that race, age, gender, and ethnicity should be the new rage in arbitration.
Well said. Thank you. Thank you. Anyway, thank you everyone for your participation, and I hope to the audience that you enjoyed the discussion. Unfortunately, we didn't have a chance to specifically address the Q&A, but what we will do is we will send that across to our panel, and we will get back to the respective contributors individually on the questions that you've posed. So thank you very much for that, and to SIAC for this opportunity. Thank you. Bye-bye.
Thank you all for that exciting session.